Hello students, today we are going to start third unit. In this third unit we have to study following subunits. First one is meaning, definitions and essentials of indemnity and guarantee. Then bailment and pledge, distinction between indemnity and guarantee, and distinction between bailment and pledge. So these are the 4 points which we are going to discuss in this third unit. Indemnity and guarantee. We will start with indemnity and guarantee. Now, what does sections 124 to section 147 of Indian Contract Act contains the provisions regarding indemnity and guarantee. So first we'll start with contract of indemnity. What does it mean by indemnity? So what is the meaning of indemnity? So to indemnify means to compensate or to give an assurance to compensate against any loss. So the meaning of the term indemnity is to indemnify means to compensate. That means one person is giving an assurance that if you suffer a loss, I will compensate that loss. That is contract of indemnity. Definition of contract of indemnity as per section 124. So section 124 of Indian Contract Act defines indemnity as it is a contract by which one party promises to save the other from loss caused to him. So one party is giving an assurance that if you suffer a loss, I will compensate that loss. Loss caused to him. How? By the conduct of the promisor, by the conduct of the person who is giving a promise, who is giving an assurance, or by the conduct of any other person. So it is not necessary that the loss should be caused by the conduct of promisor only, but it may be caused due to the conduct of third person or any other person also. In contract of indemnity, there will be two parties. The one is indemnifier or promisor. Who is indemnifier? The person who promises to indemnify is called as indemnifier. And indemnity holder. Who is indemnity holder? The person whose loss is to be indemnified, that person is called as indemnity holder. So in a contract of contract of indemnity, there will be two parties, indemnifier, the person who promises to indemnify, and indemnity holder, the person whose loss is to be indemnified. Example of it is X and Y goes to shop. So two people X and Y, they go to a shop. X says to shopkeeper, if Y fails to pay, I will pay. That means X is promisor or X is indemnifier. He is giving an assurance, he is giving a promise that if Y fails to pay, I will pay for that. X is indemnifier and Y, whose loss is to be indemnified, he is the indemnity holder. Contract of fire and marine insurance. So contract of fire insurance, marine insurance, these are the contracts of indemnity. So in this case, the insurance company gives an assurance, gives a promise that if the promisee suffers a loss, that loss will be compensated. So contract of fire insurance, marine insurance are contract of indemnity. Next type of contract is contract of guarantee. Section 126 of Indian Contract Act defines a contract of guarantee as, what is the definition? So a contract to perform or discharge the liability of a third person in case of his default. So what is a contract of guarantee? In contract of guarantee, one person is giving a guarantee regarding performing or discharging the liability of third person. If he will not do that, I will do that. If he will not pay, I will pay for that. So this is contract of guarantee. X promises to pay Y if Z fails to repay the loan of Y. So X is giving a guarantee. X is a promisor or guarantor here or surety here. He is giving an assurance to Y regarding what? Regarding repayment of loan. He is telling Y that if Z will not pay your loan, I will pay the loan. So in case of contract of guarantee, there will be three parties. One person is the surety or guarantor. Here in this case, who is the surety? X, who is giving a promise, who is giving a guarantee. He is called as surety. Now, whose loss is to be compensated, or who is to be paid? Who has given money to Z? Y has given money to Z. So Y is creditor. Who has taken the money from Y? Z has taken the money from Y. So Z is principal debtor. So in contract of guarantee, there will be three parties. Surety, X. Here X is the surety. Creditor who gives money. So Y has given money to Z. Z is the principal debtor. In contract of guarantee, there will be three parties. The person who gives the guarantee is called as surety. The person in respect of whose default the guarantee is given, he is called as the principal debtor. And the person to whom the guarantee is given, he is called as the creditor. So in contract of guarantee, there will be three parties. One person is principal debtor. He is in need of money. So he goes to creditor. Creditor is not ready to give loan to principal debtor. In this case, the third person comes in the picture. He is the person who is known to both principal debtor and creditor. He gives an assurance to the creditor that if principal debtor fails to repay the loan, I will repay the loan. This person is called as surety. So in contract of indemnity, there will be two parties, indemnifier, indemnity holder. In contract of guarantee, there will be three parties, surety, principal debtor and creditor. Guarantee. Guarantee is a promise. For what? To pay the debt owed by third person in case the latter does not pay. Means if the principal debtor makes default in repayment of the loan, then the surety will be liable to repay that loan. So the primary liability is that of the principal debtor. If he fails to pay, then the liability of the surety comes into existence. So creditor should first ask for repayment of loan to principal debtor. If he is unable to repay it, then he can ask for the repayment of the loan from surety. After paying the loan of principal debtor to creditor, then the surety can ask that amount from principal debtor. Whatever he has paid to creditor, he can ask for repayment of it from principal debtor. What are the essentials of valid guarantee? First thing is existence of principal debt. So there has to be some debt. Regarding that debt, the guarantee has to be given. So there must be existence of liability. Which liability? The liability which is enforceable at law. If there is no liability, there is no contract of guarantee. Second point is consideration for a contract of guarantee. So as we have seen in case of contract, how important consideration is, in the same way consideration is important in case of contract of guarantee. There should be no misrepresentation or concealment. So any guarantee which has been obtained by means of representation made by the creditor or with his knowledge or assent. So if there is any misrepresentation and in order to deceive surety, there is any concealment about the thing which is between only principal debtor and the creditor, regarding which surety does not know. So there should be no misrepresentation or concealment. If there is any misrepresentation, concealment, something which is done without the knowledge or assent of surety, in that case, that contract of guarantee will be invalid contract of guarantee. Again, the contract of guarantee should have all the essentials of valid contract of guarantee. So these are the essentials of valid contract of guarantee. Thank you.